Hello, everyone, and welcome to the session on competition, mergers, and standardization in vertically integrated industries. We are going to talk about a handful of cases, and this recording is a kind of a bit of to warm you up, start up for the real session that we have on Sunday, wherein we are going to talk about the Google Motorola as a case study and what are the implications of it for business strategy. So, in this very short recording, what am I going to do today is give you a brief overview about what are the issues that we are going to touch upon in Sunday's lecture. And also, I'll briefly be discussing some very recent cases. Now, these are more of standard essential patent and friendly licensing related cases, but they do have implications even from merger perspective, as you would realize that one of the remedies which was recommended by the Chinese Competition Authority and the letters which were taken into account by the DOJ in the US and the European Commission on this side of the Atlantic both referred to the relevance of standard setting and friendly licensing in order to ensure continued innovation in the highly dynamic, convergence-driven telecommunications sector. Now, as you might recall from your other classes and other sessions dealing with competition policy and business strategy, now patents are a key to innovation. They are extremely important. And therefore, while commercializing his innovation or setting it as a standard, it is very important, a top priority for the patent holder to ensure that his returns on his investment are maximized. So, likewise, the business owners who are producing outputs, let's say a smartphone using these patents, they also want to produce and manufacture products that first of all conform with the standards, and secondly, they want to ensure that this is done profitably. And from the consumer perspective, both the price and the interoperability of the products they purchase remain of importance. Now, in this respect, standard setting organizations play an important role, and standardization is at the heart of all these policies, and so is the SEPs and all the related issues. Now, against this backdrop, Google at one point of time acquired Motorola's huge patent portfolio for about 12 billion US dollars, one of the big transactions, and at the time the biggest transaction that Google ever made. Now, one of the issues which was discussed, and as I said at the outset, was also referred to in the remedies, was how does Google kind of use these patent portfolios ex post, meaning once they have been acquired by Google following this acquisition, what does Google do with these patent portfolios? Does it enter into these litigations, what we call friendly litigations? How does it impact follow-on innovation? And in this regard, I'll refer you to three very important and recent cases which deal with the subject of how these friendly licensing wars and standard essential patent related wars have gone on the two sides of the Atlantic. More particularly, I want you to take you to two decisions. I'll start with the discussion on the 2015 reference to the Court of Justice of the European Union, which is known as the Huawei decision, and then how it comes to its very good implementation in terms of practice, in the sense of the Unwired Planet and Conversant cases in the UK and the Siswell versus Higher decision of the German Federal Court of Justice Cartel Senate. So these are two very relevant decisions that we are going to discuss today. But first, a little bit of a brief background about it. Now, when I talk about, and this is most relevant from competition law perspective, looking at the practice of the European Commission, So, for example, and I would start this discussion in the European context from the Motorola and Samsung decisions of the European Commission, because this is where the Commission comes out with the concept of what we call a safe harbor concept for willing licenses. So, what is meant by that is that. The Commission goes on to say that a standard essential patent holder abuses its dominant position when it seeks an injunction against a licensee who's willing to take one such license. Now, what is meant by that? The Commission goes on to say, now let's say the alleged infringer agrees to take a license and it agrees to be bound by the determination of friendly royalties, which might, for example, be set by arbitration or the relevant court under consideration, then in such a case, it should be considered to be a willing licensee and no injunctions should be granted against one such so-called alleged infringer. And obviously, the court also goes on to, the commission, goes on to say that the willing licensee should remain free to challenge the validity of such a patent, its alleged infringement, and the essentiality of a standard essential patent. So, what is meant by this? Here, the commission kind of sides with what also patent scholars have said, that we have a major problem with our patent system. In other words, it's far from perfect. However, because it is still a system that best ensures that innovation stays on in the market, so we still continue with our patent system. However, we should be aware that not every patent that comes into the market is valid. Not every patent that is declared to be standard essential, either de facto or by a standard setting organization, is indeed a standard essential patent. And therefore, the court goes on to, the commission, in this case, the European Commission goes on to say it is very, very important to keep it open for this willing licensee to also retain the possibility to challenge the validity, the alleged infringement, and the essentiality of the standard essential patent. Why? Because this is in public interest. And as patent scholars have said, criticizing the current state of affairs of the patent system, particularly in the US, what we should be looking for is perhaps probabilistic patents and not just looking at patents promoting innovation, as we simply put it, on a whole. Now, against this backdrop, there comes a dispute, a patent dispute before the Düsseldorf Regional Court in Germany, and this is known as the Huawei versus Zte case. And this was basically a patent dispute between two big Chinese companies, Huawei Technologies and the Zte Corporation. And the problem that Düsseldorf Regional Court was confronting at this stage was, now in Germany, up until this Huawei decision, what we had was a landmark decision which is actually seen to be more patentee friendly, and it is said to be the Orange Book decision. And then on the other side, we had this Samsung Motorola decision of the European Commission, and Düsseldorf Regional Court had an issue because if it applied the Orange Book standard to the dispute between Huawei and Zte, it would lead to granting the requested injunction. However, if the Düsseldorf Regional Court were to follow the approach of the European Commission that I just said to you at the outset of this discussion, then it would lead to a dismissal of the action which was brought by Huawei, and there would be no injunction that could be granted on the basis of competition law defense within the meaning of Article 102, subject to the interpretation of what exactly is willing licensee. Remember, willing licensee has to be confirmed from the facts of the case. So it's very factual in that case. And you have to see whether the licensee is indeed willing or not. So then basically what happens is the Düsseldorf Regional Court comes up with a handful of questions. It refers to the Court of Justice of the European Union for a preliminary reference under Article 267 of the TFEU to clarify the circumstances under which an undertaking which is in a dominant position abuses that position by bringing in action for infringement. And then the Court of Justice of the European Union delivers its preliminary opinion, a very, very interesting opinion therein, wherein kind of sets a procedural framework which balances the interests of SEP holders that are seeking injunctive relief and the alleged infringers. Now, remember what CJU does in this case is it is setting up a procedural framework. It is telling certain step-by-step things in which you look at this has happened, you kind of tick the check boxes, and then you determine whether a patent has indeed the patent that has been infringed and whether the licensing is willing or not. But it doesn't set something in stone. So this procedural framework, in other words, is still subject to interpretation by what the national courts of the European Union's member states do to be able to implement these guidelines and resolve the questions that remain unaddressed. Now, against this backdrop, I'll quickly take you to two very important decisions, very recent and very important, and then we'll pick up the threads of this discussion. Please remember, these are all ex post competition law cases, so which means which came within the framework of abuse of dominance. And then on Sunday, I'll connect this with an ex ante merger control case, which is the Google Motorola case. So first of all, a very brief overview of the German courts. Now, there was a very interesting decision which came last year. It is known by the name Siswell versus Haier Deutschland. And basically what happens in this case is Germany's highest court, the Cartel Senate of the German Federal Court of Justice, it found that during the pre-suit negotiations, that is before the patent has expired, implementers of standard essential patents must clearly and unequivocally declare their willingness to conclude a license agreement on fair, reasonable, and non-discriminatory terms. And if they fail to do so, then those implementers may not be able to hold the patentee, that is the SEP holder, liable for any anti-competitive behavior. So this was the key ratio descendi, the key crux of the decision in Siswell versus Haier, which is of relevance. And then the court also goes on to offer guidance on the obligations of an SEP holder to avoid abuse of dominance charges, including in the context when there's a demand for worldwide SEP portfolio license. Now, what ultimately, in short, this decision of the court offers in Germany is an important guidance to both patentees and the users, in other words, potential infringers, about the steps which are necessary to avoid abuse of dominance allegations and invoke rights to a friendly license in Germany. Now, this is not to say that each and every question has been solved. There are still issues which remain unresolved. As an example, SEP holders can demand SEP portfolio or worldwide licenses without necessarily abusing their market dominance. In order to avoid this, the SEP holder that is seeking a license must provide notice to the implementers that the implementers are infringing particular SEPs or portfolios, and having received such a notice, it retains its right to friendly terms and ability to raise an Article 102, in other words, abuse of dominance defense. For this, the implementer must clearly and unequivocally signal a willingness to take license on friendly terms to be deemed a willing licensee. And what implementer in such a case needs to do is he should not delay in responding. Why? Because unreasonable delay itself demonstrates that you're unwilling to take a license in the first place. So this was the key steps, which was in a certain sense, if I can say, clarified as regards SEP litigation in Germany in the Siswell versus Hire case. And quickly, I'll not go into the details, but need to offer an overview, is the Unbiased Planet and the conversant cases, as they are called. Now, they all again involve these 2G, 3G, and 4G telecommunication standards for mobile phones that were established by ETSI's policy. It's a standard setting body. And basically, the Supreme Court makes a few very important points, including the ability to offer worldwide global licenses, which has been seen worrisome as by many courts. Why? Because this, in other words, can kind of lead to forum shopping, if I can say that. So in short, in this case, what the court goes on to say is that an English court retains the possibility to determine friendly terms, including the royalty rates, of a global license to a standard essential patent, even without the consent of the parties. Now, as you can imagine, renowned scholars immediately came up with commentaries and said, no, this is really problematic. It can lead to worrisome outcomes. And then some other scholars were of the opinion that perhaps having a global, a possibility to have a global license in one forum can kind of balance the various interests. In the other sense, you can minimize your transaction costs of negotiating across different forums. And second, the court in the UK also said that English courts have the possibility to enjoin a party from infringing the UK counterpart of a standard essential patent unless that party enters into one such global license which is offered. Now, one of the bases of this reasoning by the Supreme Court in the UK was the contractual obligations that members made to the ETSI, which is the European Telecommunications Standards Institute, a standard setting organization which is based in France. So it is subject to French laws, including the law of contract, as well as certain commercial realities of how patent system is working currently and how technical standards are set in the telecommunications industry. And there are lots of other finer details into this judgment, but this is one of the key aspects that I want to reiterate and remind you. That court goes on to say that there remains a possibility to offer worldwide licenses. Now, with this, I would close this short recording. What we are going to do on Sunday, that would be the 21st of March when we have a live session. I'm going to go into the details of one very classic ex-ante case of mergers, standard setting, and the potential cases of abusive behavior, and how these have been addressed differently by different competition authorities, most notably the Department of Justice in the US on the one hand, the European Commission on this side of the Atlantic, and the Chinese Competition Authority on the other. And we are going to do this with a case analysis of Google Motorola, which was decided by all the three competition authorities. And most notable was, whereas the US and the EU cleared the merger unconditionally, the Chinese competition authorities came up with some very detailed remedies, structural or non-structural. Again, we'll discuss this because the definition of what is a structural remedy and what is not is again subject to a lot of debate. And then we'll finally conclude this session with what would be the lessons for business strategy. In the meanwhile, I have shared some set of recommended readings. Should you have a moment, please read them and I'll be happy to take your questions in the live session. Thank you very much, and I look forward to seeing you all on Sunday. Thank you.